Hey everyone, and welcome back to the podcast. Today we're diving into a topic that honestly, many of us probably don't think about until we absolutely have to, and that's estates. It sounds a bit formal, right? But it's something that affects virtually everyone at some point, whether it's our own or a loved one's.
Absolutely, Sean. It's one of those subjects that can feel overwhelming, shrouded in legal jargon, and let's be real, it often comes up during a time of grief. Our goal today is to really demystify it, break down what an estate actually is, and what happens when someone passes away with or without a will.
Yeah, I think that's super important. So, Diane, let's just start with the basics. When we talk about an estate, what exactly are we referring to? Is it just someone's house or is it broader than that?
That's a great question, Sean, because it's definitely broader than just a house. An estate, in legal terms, essentially encompasses everything a person owns and everything they owe at the time of their death. So we're talking about real estate, their home, any land, but also personal property like cars, jewelry, bank accounts, investments, even their personal belongings. And then crucially, it also includes all their debts, mortgages, credit card balances, loans, medical bills. It's the full financial picture.
Wow, so it's a whole lot more than just assets, it's the liabilities too. That makes perfect sense. So once someone passes, what's the first step in dealing with all of this? I hear the term probate thrown around a lot. Is that always the case?
Probate is a big part of it, but not always the very first step for every single thing. Generally, when someone dies, their estate needs to be administered. This process is often supervised by the court to ensure that all debts are paid and the remaining assets are distributed correctly to the legal heirs or beneficiaries. The probate part specifically refers to the legal process of proving the validity of a will and then carrying out its instructions, or, if there's no will, determining who inherits based on state law.
Okay, so probate is the court's way of overseeing the whole thing. What if someone has a will? That makes things straightforward, right? They've laid out exactly what they want to happen.
In theory, yes, a will makes things much clearer, but it still has to go through the probate process to be legally recognized. The person named in the will to manage the estate is called the executor or personal representative. Their job, once the will is validated by the clerk of superior court, is to essentially step into the shoes of the deceased. They gather all the assets, pay off any outstanding debts and taxes, and then distribute what's left according to the will's instructions. It's a significant responsibility.
That sounds like a massive undertaking, especially during what's already a difficult time. So the executor has to compile a full inventory of everything? That must be painstaking.
It absolutely is. The executor has a fiduciary duty, meaning they must act in the best interests of the estate and its beneficiaries. They have to file an inventory with the clerk of superior court, detailing all assets. They also have to publish a notice to creditors, giving anyone owed money a chance to make a claim against the estate. This is all part of ensuring fairness and proper legal procedure. It's not just grab the will and hand out the stuff.
Right, it's a structured legal process. Now, what about the flip side? What happens if someone dies without a will? I've heard that term intestate before. Does the state just take everything?
That's a common fear, but no, the state doesn't just take everything. When someone dies without a will, they are said to have died intestate. In this scenario, state law, specifically the laws of intestate succession, dictate how the assets of the estate will be distributed. These laws typically prioritize immediate family members, a spouse, children, parents, or siblings. It's a predetermined hierarchy.
So it's not arbitrary, there's a clear legal framework, but I imagine it's still more complicated and potentially contentious than if there was a will.
Oh, absolutely. Without a will, the court appoints an administrator instead of an executor. This person has similar duties to an executor, but without the specific guidance of the deceased. This can lead to delays, increased costs, and sometimes family disagreements over who should administer the estate or how assets should be divided, especially if the state's default distribution doesn't align with what the deceased might have wanted.
That's a huge point right there. It highlights why having a will isn't just about being prepared, but also about preventing potential stress and conflict for your loved ones. What if someone's estate is really small? Is there a simplified process for that?
Yes, thankfully there often is, depending on the state. For smaller estates, many jurisdictions offer what's called a small estates affidavit, or a simplified administration process. This allows heirs to claim property without going through the full, formal probate process, which can save a lot of time and money. There are usually strict limits on the total value of the estate to qualify for this, but it's a great option for many people.
That's really helpful to know. So what's considered small in this context? Are we talking about a few $1,000s, or can it be more substantial?
The exact threshold varies by state. For example, in North Carolina, the limit for personal property is currently $20,000. If the surviving spouse is the sole heir, that limit goes up to $30,000. It's important to check the specific limits for your state, but it certainly streamlines things for many families who might otherwise struggle with the complexities of a full probate.
Okay, that's good to have a ballpark. So we've talked about wills, no wills, and small estates. What are some of the common challenges or misconceptions people have when it comes to estate administration?
One major misconception is that joint ownership automatically avoids probate. While some jointly held assets with rights of survivorship, like a joint bank account, can pass directly to the co-owner, not everything does. Real estate held as tenants in common doesn't automatically transfer, for instance. Another big one is believing a will is enough. A will is crucial, but comprehensive estate planning often involves other tools like trusts, which can help avoid probate altogether for specific assets, provide for minor children, or even manage assets for beneficiaries with special needs.
That's a fantastic point about trust. I think a lot of people see trust as something only for the super rich, but they can be incredibly useful for families of all income levels for specific goals. What about family dynamics? Does the court typically get involved in disputes?
They absolutely can, and unfortunately, they often do. If there are disputes among heirs about the validity of a will, or how the administrator is handling the estate, or even interpretations of a will, those matters can end up in court. This is why clear, unambiguous language in a will is so vital, and why having a professional draft it is usually a good idea. Ambiguity just invites conflict.
It sounds like a strong argument for not only having a will, but having a well-drafted will. And it also seems like communication within families before someone passes could be helpful, not just about the will itself, but about their wishes and intentions.
Absolutely. Open communication can prevent a lot of heartache. While the legal document is paramount, understanding the why behind certain decisions can go a long way in fostering acceptance among family members. It's never an easy conversation, but it's a valuable one.
So let's talk about the role of the clerk of superior court that you mentioned. What's their specific involvement in all this?
The clerk of superior court or their assistant plays a central role in the probate process. They oversee estate administration from start to finish. This includes admitting wills to probate, appointing executors or administrators, ensuring that inventories and accountings are filed correctly and on time, and generally supervising the entire process to ensure it complies with state law. They're basically the judicial oversight for estates.
So they're not just a passive recipient of documents, they're actively ensuring everything is done by the book. That's a huge layer of protection, I imagine.
Exactly. They are there to ensure fairness, prevent fraud, and make sure that the deceased's wishes or the state's laws are properly executed. If disputes arise or if an executor isn't performing their duties, the clerk's office is often the first point of contact for intervention.
That brings up another practical point. What if someone is appointed executor or administrator and they just don't want to do it, or they realize they're in over their head? Can they decline that responsibility?
Yes, absolutely. You can decline the role. It's a significant commitment and responsibility, and not everyone is prepared for it, especially during a time of personal loss. If the named executor declines, the court will then look to others, typically a backup named in the will, or if none, then an eligible family member, or even a public administrator if no one suitable can be found. It's not something you're forced to do.
That's a relief to hear, because I imagine it could be an enormous burden for some. So Diane, if someone is listening right now and feeling a bit overwhelmed by all this, but knows they need to get their affairs in order, what's your top piece of advice?
My top advice is to start with a conversation with a qualified estate planning attorney. Don't try to navigate this alone or rely on online templates without understanding the nuances of your state's laws. An attorney can help you understand all the options, from a simple will to more complex trusts, powers of attorney for finances and health care, and help you tailor a plan that truly reflects your wishes and protects your loved ones.
That's solid advice. It's really about proactive planning to ensure peace of mind later on. I mean, we plan for so many things in life, retirement, vacations, but sometimes neglect this crucial piece.
Exactly. Think of estate planning as one of the most loving and responsible things you can do for your family. It removes so much uncertainty and potential strife during what will already be a very difficult time for them.
Absolutely. It really boils down to having a plan, no matter the size of your estate. Even if you think you don't have much, you still have wishes about what happens to it and who takes care of things. Thanks so much, Diane, for shedding so much light on this often confusing topic.
My pleasure, Sean. I hope it helps our listeners feel a bit more empowered and less intimidated by the process.
And to all our listeners, thank you for tuning in. We hope this episode has given you a clearer understanding of estates and perhaps motivated you to start those important conversations and planning. We'll catch you next time.